Well, hello, everybody, and welcome back to Hangouts and Headlines. I know it's been a little while since we had our last episode, but I am so thankful to see all of you here already this early in the morning on a Thursday. I believe I've got the day of the week right. You never know in the summertime. But welcome. We're going to talk about some fun stuff today. We're going to talk about Disney. And if you aren't familiar with this channel or this show, we're going to hang out first. We're going to talk about a few things, catch up with some of the folks that are regulars here on the channel. And then we're going to get into the headlines. So I know some of you don't like the hangout. Some of you don't like the headlines. I've tried to add a few more visual cues to our process here so that you know what it is that we're talking about. And then you can wait to see when the headlines start. I'll also be adding chapters in the description of the video after the show is done, if you'd rather wait for that. But with that said, let's jump into some hangouts. So everybody, I haven't done a hangouts and headlines in a couple months now. How are you all doing? Where are you from? Where are you checking in from? How's your work life going? How's your social life going? How do you feel about Disney in general? How are things with everybody in the Hoeg Law YouTube community or anybody else that's dropping in? Got a lot of good mornings here. Shell with good morning. Good morning from Lynn. Good morning to you both. Half-Blood Hella says, howdy from Phoenix. About to make me a brown sugar cold brew coffee. Heart emoji and party popper emoji. Well, enjoy that. I don't have any idea what that would even taste like. So thank you for sharing. Pants says, good to see you, Rick, coming at you from New Hampshire. Well, good to see you, Pants, and your dog there in the profile photo. Sharon made the live. You did, in fact, make the live. And it hasn't been very often that we've been doing lives in this last little while. And I know folks yell at me in the community for apologizing for that, but I do want to say that it has been a trip this year in 2024 to figure out exactly what I can and can't do with my work schedule and the firm and this channel. And so I appreciate all of you for waiting for me here to come back live. And hopefully I can get this on a schedule that is a little bit more regular, a little bit more often. So thank you to everyone there. Letitia made this here from Dallas. I hope Dallas is comfortable this time of year. I will tell you, I was just on vacation in July. We went down to the Caribbean and to Florida, ironically enough, to Disney World, as we'll talk about as part of this video. And it was really, really hot. I'm certainly not used to that level of heat and humidity here in Michigan. And I had a very good vacation, had a great time, but it was sweltering as soon as you went outside. So I hope Dallas is maybe a little bit more comfortable than Florida was in July. But either way, I hope you're having a good one. Sue Lillard wants us all to know that Deadpool and Wolverine was great. I had a couple of people ask me about Deadpool and Wolverine. I have to be honest, Deadpool is not really my type of humor. So I didn't rush out to see that. I didn't love the first two, and I've tried. My brother adores the first Deadpool movie. I don't know how he feels about the second one. But I have not run out to see Deadpool and Wolverine. But I'm glad to hear that you enjoyed it, Sue. Brentwood Chic, hi all. Hi, Brentwood. Regular here on the channel, so nice to see you. Powerpuff 4, hi, Hoeg. So great to see you back. I'm in Florida, and I'm interested on your take. I don't see how Disney can apply arbitration from the Disney Plus terms and a park to a Disney Springs restaurant. Yeah, well, we're going to get into that when we get into the headlines, definitely. I will say it is both more and less crazy than the headlines make it appear. So we've got some fun to go over with the legal side of things, as well as the communications on the media side, as part of this conversation. So I'm glad you're here. I'm glad folks are interested in this topic. I thought it was really interesting when I saw it. A number of people flagged it for me in my DMs and other messages. And I knew immediately that it was the one that I wanted to come back with because it is such a weird kind of story. B19 says, good morning from Lower Alabama. Enjoying my coffee here. So happy to catch a live. Happy to have you here, B. Thank you so much. Really appreciate it. Lara says, first day of school for the kids is in a little over a week. Yeah, our kids start school after Labor Day. So it's a little bit later here in Michigan. Can't wait to have the house back as I work from home. Smiling, sweating, crying emoji. Yeah, I get that. I certainly get the difficulties in having to kind of claim space in an area when there are other people running around. And right now, my eldest is in driver's education, if you can believe it. So she's out of the house right this second. But they're both going back to school just after Labor Day. All right. And I will try to grab these member chats and the super chats and everything else that you guys are so nice to help support the channel with when I see them. I am getting used to the buttons again, having been away for a little bit. So advanced apologies for that, I guess, but we haven't made a mistake yet. Emily, member for 22 months. Thank you for being here for almost 2 years, Emily. Almost 2 years. Good to see you again, Hoeg. I'm in Milwaukee and have no opinion on Disney. Smiling with lots of teeth emoji. You have no opinion on Disney whatsoever? Well, then your open mind will be best able to tell us exactly how you feel about this story we're about to go over today. But I hope things are good in Milwaukee. The teacher made this has always loved Disney until the last 8 years or so. Disney has changed too much. Disney has had a run of kind of not so terribly well-received movies. The theme parks that we visited are not the same as they were when I was a kid, but we had a lot of fun anyway. And so, I mean, I recommend it if you can go, but it isn't the same kind of experience as it was when I was going primarily in the 80s and 90s. Caden Banford, hi from England. Been very busy dealing with a 15-week-old teething puppy. So this should be a nice break from all of that for a little bit. Yeah, I hope so. I hope there are no teething puppies involved in this particular show for you or for me. But I hope that's going well. I've never actually had a puppy, so I don't know what teething a puppy is like. But if it's anything like teething your kids, it can be a trying time. Rhea Soon says, here from Ontario, Canada, the border with Michigan. Indeed it is. Ontario, Canada is one of the few places in the world where Canada is south of the United States for a little bit. That's one of Detroit's claims to fame. We have very few of them. So, you know, we've got that one that we tell people when they visit. Stephanie Who says, I noticed Disney Plus doesn't allow me to watch with a VPN anymore. So right now I'm angry at Disney because an old show I wanted to watch is only on Disney Plus UK. Crying emoji. Yeah, I didn't know that. I don't access my Disney Plus account with a VPN, but it doesn't surprise me that they're trying to crack down on some of that stuff. And I'm sorry to hear you can't get access to what you want to watch. Brentwood Chic, thank you so much for gifting so many Hoeg Law memberships. I really appreciate that. Your support is very, very helpful to keeping this channel going. And I'm going to try to do more and more of these videos, not like we were doing in 2022, but more than we've been doing in the last month or so. And I really appreciate the support. Britt, thank you for the support for the $5 super chat. Disney has had a run of bad movies. Is like saying Bungie has hired too many people. It's a bit of an understatement. Well, I think there's some truth there, but I did grow up loving Disney, and I did enjoy watching older Disney movies with my daughters while on vacation. So we didn't really watch a lot of the stuff from the last 10 years or so. Not that that's a specific deadline, just we watched movies primarily from the 90s, as well as Princess and the Frog, which we all really like in the Hoeg family. So yeah, Disney's had some troubles. And Disney has taken out those troubles on things like increasing prices at the parks and making somewhat crazy claims in lawsuits, as we will see in just a minute. HP says Disney needs someone at the top who doesn't just care about dollar signs and actually understands why people like Disney, or at least makes a focus on their stories in their movies. Yeah, I mean, one of the issues that I have with Disney is their focus on intellectual property. I preferred the theme parks, the Walt Disney World experience, when there were things that were their own animal, if you will, Pirates of the Caribbean and Haunted Mansion and things like that, that were built for the parks and then later made into IPs with things like the Johnny Depp movie series. But they're moving towards having everything that they add into the parks be intellectual property focused. So things like the Universe of Energy at Epcot got changed out for Guardians of the Galaxy Cosmic Rewind, which isn't a good fit for Epcot as a theme at all. But I will say the ride itself was fantastic. I was not expecting to like it as much as I did. And I think the Guardians ride in Epcot is a wonderful experience, almost as good as some of the stuff at Universal in terms of thrill rides and giving you an exciting time. But I do wish that Epcot had kind of stuck with its pavilions talking about the future and things like energy and automation and having those kinds of conversations. I thought was a unique spin on the theme park environment, and that's pretty much gone now. HP says Inside Out 2 was amazing, though, partly because it didn't feel like just a cash grab sequel, but like there was still an important story to tell. It made me cry. So Inside Out 2 was a movie that I saw this summer with my family. I do want to say I don't think it's a bad movie. I think it is a bit of a sequelitis type movie. It follows very similar plot patterns to the first one in terms of what happens in it. I don't want to give spoilers since it's so new, but there are aspects of it that I liked, especially going through some of the stuff I've gone through after my stroke. And there are other aspects that I thought maybe they didn't pull off as well as they could have. So Inside Out 2 is kind of a middle type movie for me. Angelique says loved Inside Out 2. So we got at least a couple people in the chat right now that adored Inside Out 2. The fact that I thought it was fairly middling does not mean that I'm the final arbiter of this. And we're going to be talking about arbitration as part of this video. But if you are interested in the subject matter, you've got a couple people in the chat that say they love it. Maybe you'll love it too. Or you might wind up like Mystic Barking Cow. Inside Out 2 was only okay for me. So there you go. We don't know. That's why we hang out. We learn things about other people, and other people like or dislike things differently than us. And as I like to say, it would be very boring if the entire world was composed of just ourselves. So it's good to have those reasonable minds differing on things like this and enjoying each other's company and having these kinds of conversations without getting into an attack on whether or not Inside Out 2 is the best thing ever or the worst thing ever. So it's one of the reasons I like doing these videos. I like having this community. I like having this channel, is to have conversations like that don't kind of divide and conquer the way I see so often in places like Twitter. So, all right. Let's go to one of the other Hangout topics I had. What is your favorite duck-based Disney character? And I asked this because my youngest daughter is absolutely obsessed with the DuckTales, and we watched a lot of DuckTales over our vacation and this summer. Do you have a preferred duck-based Disney character? I'm sure it will come as no surprise to many of you that mine is probably Scrooge McDuck, not for his money bin, not for his materialism, but for his sense of adventure and wanting to go out and find dinosaurs and things on the moon. But yes, here's Mrs. Hoeglaw yelling Scrooge McDuck either at me or because it's her favorite. And if it is her favorite, I appreciate it. I think I remind her of Scrooge McDuck sometimes with the way I budget things around the house. But yeah, thank you, honey. I appreciate it. I'm glad you're in the chat. Akaruki says Darkwing Duck. Yeah, let's get dangerous, right? Darkwing Duck. Absolutely. Thank you so much. This is why we hang out. We got to find out what people's favorite duck is. Is anybody's favorite duck Launchpad? I've never fully understood the Launchpad McQuack character, and I'm interested if anybody really has that as their favorite. Safira Estiva says that is very fair. Donald Duck, unless he's in Kingdom Hearts. LOL. He's a sorcerer in Kingdom Hearts. What's wrong with Donald Duck's depiction in Kingdom Hearts? I have questions on this. But I do love Donald Duck, certainly. And one of the things that my daughter says is that Donald Duck, her favorite animation of him, the favorite way he looks, is in the new DuckTales. He's got a black sailor's uniform instead of the kind of more traditional blue. And she loves the way that Donald Duck looks. Are Huey, Dewey, and Louie one character? No. If you watch the new DuckTales, they have very different drives and motivations. Louie is very money motivated. Dewey is kind of an oddball. Huey is the de facto leader of the group who's into the Woodchuck guidebook and everything else. So they're not one character, but you can like one or all three individually. Darkwing Duck says Star Max. A couple of Darkwing Duck votes already. Furu says the new DuckTales is one of the better reboots. I love the new DuckTales. And one of my favorite bits of the new DuckTales is that they adopted the moon music from the NES DuckTales game, the old Nintendo, right? Back when the pixels flickered and it was just a gray box you had under your TV. And the moon music was one of the kind of really popular bits of music from that era because they did such amazing things with like 8-bit music sounds. And they adopted that song and made it into the lullaby in the new DuckTales. And I think that's just fantastic. Against the Tide says the original DuckTales or the new DuckTales? The new DuckTales. She loves the new DuckTales and has been holding on to whatever happens in the third season for years. And I promised her that I would watch it with her, and we had to watch the first 2 seasons first. So we basically went through those in like a week, and my wife was sick of the DuckTales theme song by the time we were done with that. Believe me. She was so happy to get home and be able to change something on the TV to this, that so it wasn't DuckTales. Britt says Donald have to go with the OG. Donald Duck, it's where it all starts. Absolutely. Scrooge McDuck says Sardinisms because of Dreamlight Valley. If you haven't played Dreamlight Valley, folks, Scrooge is the one that is helping you to build the stands and various things around the valley. And so I can understand liking him. He also helps you furnish your house and buy decorations. So Scrooge McDuck out there making money in video games as well as cartoons. Couple more Darkwing Ducks. People like Drake Mallard. Darkwing Duck. Midnight Jury and Mind of Garenth. Thank you so much. Oh, I like this answer. Georgia Heisterman says Professor Ludwig von Drake. I remember like Adventures in Mathland and various of the other old Disney cartoons that were educational, and Ludwig von Drake being there and teaching things from a kind of old manic professor standpoint. So yeah, it's great. Pants. Ooh, Launchpad. He's not a duck though. Is he not? He's got a big, what kind of bird is Launchpad? Is he a seagull? Is he a pelican? I'm curious about this. I've never really thought about the fact that Launchpad McQuack is not a duck. So this is very eye-opening for me. This is today I learned. 0 days since I found out Launchpad is not a duck. All right. Have to think about these things. Emily says probably Scrooge voiced by David Tennant. Yeah, it took me a minute to get used to David Tennant as Scrooge McDuck, but he's very good in it. Very good in it. So, yeah. Let's see here. Eva Leah Starstev says Launchpad taught me that any landing you can walk away from is a good one. It is, right? If you can walk away, it's good. Survive and advance. A lot of people agreeing with Ludwig von Drake. I agree. I think it's a good call. And I am very appreciative of the out-of-the-box thinking here. So, yes. Kelly Godley says not Disney, but had to add Count Duckula. Count Duckula. It's Count Duckula Looney Tunes Adventures. See? My information is not perfect on this. We can talk about law. We can talk about arbitration provisions. We can talk about news media. I don't know all cartoon ducks. Sathira says Donald Duck is useless. He dies near instantly all the time, and when he runs out of MP, no damage. In Kingdom Hearts, not in general. But yeah, I can understand that. The glass cannon mages are difficult to keep alive. Tisha says my daughter's first words were Donald Duck. Cool. Akaruki says semi-duck related. Has anyone played One Honk Before Midnight, a goose-themed RPG? I have not played One Honk Before Midnight, although I am curious about this. I did play a game called The Duck Detective, which was a cartoon mystery in which a duck had to solve for a import-export murder of salamis. And what really worked about this particular game was that the duck was voiced. It was voice acted, and he sounded like this. It was a dark night on the duck trail, and those breadcrumbs were too much for me. I have to get off the bread like it's a drug addiction. And it's really an interesting take on ducks and noir detective stories. So if that sounds interesting to you, played it with my daughter. It was a good time. You guys can check it out. It's an indie game. I have not played One Honk Before Midnight, though, Akaruki. I'm sorry about that. Sardinism says, freaking heal me, Donald. They never cast the spells you want when you want them to, right? Yeah. Donna says, hubby watches DuckTales, but I'm more Pokemon. I get that. Star Max says new DuckTales was great. Was a great boot. Was a great reboot, I think. Yeah. Here's the re. Came in a little later. Magica Dispel. See, that's a good choice. Why is Magica green? That's what I asked my daughter, and she didn't know. So Magica Dispel, green in the new DuckTales. But it's a good choice again. Lots of ducks. Disney has created a lot of cartoon ducks. Don says, Hoeg, say hi to Byron for me. His first Hoeg vid. Hi, Byron. Hi, Don. Congratulations. That's awesome. And thank you so much for the super chat. I really appreciate it. Really appreciate everybody that helps support the channel so much. Does Howard the Duck count? No. Well, he's Marvel, so he's owned by Disney. Yeah. Okay. He's Marvel and Marvel is Disney, so that's theoretically valid. See, I got there in my head, and you already had it in the chat. So I guess maybe it counts as Disney. We'll go with originally created by Disney. BR Spies, Duck Detective, my favorite game where the villain was ultimately tariffs. Kind of. It's really interesting because it is this kind of silly indie game where a duck talks to various animals that work at a bus transport company. But then, yes, it is about kind of like governance and importing and exporting and murder. So it's a weird game. It's one of the reasons I like indie games is because they can often get weird. But yeah, Duck Detective, check it out if you're interested. I do recommend it. Eddie says, hey, Hoeg, good to see you. Kelly C says, I'm only slightly surprised no one said Daisy. I have trouble with like Daisy's characterization. I don't feel like they give her enough character. I think some people could say Webigail. I know a lot of people like Webby a lot in DuckTales, but I'm not, as you say, I'm not surprised that no one said Daisy because I think that is a tough one. Britt, thank you again for the super chat. For all those that picked anyone but Donald Fauntleroy Duck. Is that Donald's middle name? Maybe. Remember this. If Donald was not popular, you would never have your duck. You owe him. See, this is the Grand Theft Auto 3 kind of proposition, right? Because people say, what's your favorite open world game? Or what's the most impactful? And I often say Grand Theft Auto 3 because it sets the stage for the other games, but it's obviously not as good as some of the games that came afterwards. So similarly, Donald, probably not as good a character as some of the other people that are being mentioned here or other ducks that are being mentioned here, but it's a fair argument. So we can accept it. All right, and I'll do one more of these before we get into the headlines, folks. So I'm glad everybody was jumping in on these kind of topics of conversation because I thought it would be a fun way to have more Hangouts with everybody. So because of the topic of the headlines, I want to know, do you get Disney Plus? Have you subscribed to Disney Plus? Why or why not? Is this something you're interested in? Let's hear it from everybody. Are you more put off by this news headline that you're seeing now that we're going to talk about today of avoiding Disney Plus or other terms and conditions from the Walt Disney Corporation? Britt says, yes, Fauntleroy is his middle name. Fair enough. Against the Tide says, I used to. I have no money. I certainly understand that. And I'm in the business. I think you've heard me say this on the Bitcast, which I'm on Sundays for anybody that's interested. That I rotate through our streaming services and then basically only turn them back on when somebody in the house yells at me because I can't get onto that service. It's like, yeah, I turned it off. So yeah, we have Disney Plus because of Bluey is probably the most accurate answer for Hoeg House. And they're raising prices and we have to figure out exactly how we're going to get Bluey in because we love Bluey here. So good answer, Kat. Thank you. Eva says, yes, subscribed and annoyed. Tammy says we canceled our Disney Plus due to the increasing cost. That's me and Netflix. Britt says, no, I would not have Disney Plus if they paid me, unless they paid me a ton. Then I will have it, but never watch it. LOL. I mean, yeah, if Disney's going to pay you, sure. HP says, I want to cancel my Disney Plus because of this, but it seems like that wouldn't change anything for me. Yeah, to the extent that their argument is upheld here, and we're going to have our issues with it. We'll talk about that when we get to headlines. The moment in time where you would be subject to this argument was when you initially entered into a trial, when you accepted their terms of service at that first instance. So that's its own problem. But if you did have Disney Plus, canceling it wouldn't get you out of what we're going to talk about. Kelly C says, no Disney Plus, and stories like this make me want to avoid it even more. I get that. I do. That's part of what I want to talk about with respect to this headline, which is to say, I'm going to talk like a lawyer for a bit of this video and talk about why Disney made this argument, why they think they might have a winner there, and why I still wouldn't recommend making that argument because of the headlines and because of what we're seeing in the media and this uptake of conversation on this particular point in various places. Bruno Marcius says, have Disney Plus because I like it and my niece loves Bluey. Yeah, I think there's good stuff on Disney Plus. I love Andor. I'm looking forward to Andor season 2. There's also not great stuff on Disney Plus. They keep trying with some of their Marvel TV shows and some of their Star Wars TV shows, and they don't quite get to the level that I would like them to be at. But other than the price raises, I haven't had a problem with the service. Pretty Fly for a Wi-Fi says, I'm mooching off my sister's Disney Plus. I'm too cheap to pay for all the streaming services. I only have Dropout now, or Droopout. I actually don't know what that is. So yeah, I'm also too cheap to pay for all the streaming services, if you want to call it cheap. I think it's just wise economics to figure out what you can actually ingest, what you can actually consume over a period of, let's say, 30 days, and not buy the stuff that you don't have access to. And then you come back to Netflix, or you come back to Apple, or you come back to whatever else you're turning on, and it has a glut of things for you to watch over a short period of time, and then you turn it back off. And that works for me, but it is a little bit of extra effort. Joanna Kate says, for Disney, lime green is evil, so Magica is evil, hence lime green. Is that true? Does Disney make green into evil? It certainly does with like Maleficent. So maybe Magica is supposed to evoke a kind of Maleficent feel. Kelly Godley says, have it, but seriously contemplating getting rid of it. Eat Fresh Guy says, I have Disney Plus and Hulu for free. Work perks are nice. They are, aren't they? Yeah. Tough Cookie says, I have Disney Plus mostly for Star Wars things. Yep. I think that's how they get you, as it were, is they have Marvel, they have Star Wars, they have some stuff that you might otherwise like to see or be caught up on. And for my family, they have Bluey and they have DuckTales. And that pretty much justifies the expense right now. Will it justify the higher expense? Not sure there, although I do want to see Andor. BS Unfortunate Initials, thank you for the super chat. Yes, I love the old animated movies. That was nice to go access, definitely. Thinking of canceling because of cost, I get that. HP wants to know if during his litigation with Disney, Ron DeSantis had Disney Plus. I think it's very possible. Disney Plus has a lot of subscribers, certainly. And yes, that's a good question based on this argument that we're going to see in just a minute. Eliza and Khan says it makes them look horrible. It does, doesn't it? This particular story makes Disney look very aggressive. Akaruki, thank you for gifting Hoeg Law memberships. And Don says Kermit is evil. Well, this is another one of those things that was not created by Disney, right? So Kermit came green. They didn't change him to a different color. I don't think Disney conceives of Kermit as evil, but I don't want to speak for them. Blaze also points out, isn't the poison apple dipped in green liquid in Snow White? Yes, but I think green liquid has its own kind of notion of toxicity, right? That lime green, the neon pink, those are kind of toxic colors. And I recognize that both Kermit and the Pink Panther are hanging out here. I don't mean to indicate that they're toxic, but I do think in liquid form, that's a suggestion of toxicity. So I get that more than I get that Magica De Spell is, for some reason, a green duck when there isn't another green duck in the show, at least as I've seen. And Johanna wants to point out that Kermit isn't the lime green. He's a more comfortable green. He can sing about rainbows in the swamp because he's a more natural green. So that might be right. I don't know. I asked the question legitimately because I don't know. And my daughter didn't really know either. So that's Hangouts for everybody. Thank you so much for having a conversation with me about these very important topics, like do you have Disney Plus and what's your favorite Disney duck? As I said, the vacation that I was on with my family was at Disney. And so I feel like I got to experience Disney and how they treat people pretty well this past summer. And while I think it's better than some folks on the internet would have you believe, there are certainly differences between Disney now and when I was a kid. Britt, thank you for the super chat. Says, what if they force you to use an app to buy tickets and or pay in the park with this type of arbitration clause, then did not provide a safe ride environment? How could that be a defense for sorry you got injured? Well, we're going to talk about that because they actually bring in the My Disney Experience app into this conversation. As I said earlier in this stream, this is both more crazy and less crazy than it seems in headline form. So we're going to get into some of what Disney has done with nesting their terms of service and terms of use and conditions in various places. and also how that probably doesn't get them out of the conversation here. But yeah, let's get into the headlines. We're going to talk about the wonderful world of Disney lawyering today. So let's get to that, and hopefully I can hit these buttons correctly still. Thank you for being with me for this. So this is the New York Post. This is not the headline that I've highlighted in the thumbnail to this video, but it is where things start. You can see this is February 26, 2024. NYU doctor dies after dining at Disney restaurant where waitstaff insisted food was allergen-free. Lawsuit. A doctor from New York University died shortly after she ate at a Disney Springs restaurant in Florida, and her bereaved husband is blaming negligent staffers, according to a lawsuit. Kinokporn Tengswan, and I am sure I butchered the crap out of that, so I apologize to the deceased. A doctor at the prestigious NYU Langone Hospital in Manhattan died suddenly after having dinner at Raglan Road Irish Pub and Restaurant on October 5th. Her husband, Jeffrey Piccolo, has filed a 19-page lawsuit in Orange County, Florida Circuit Court, accusing Walt Disney Parks and Resorts of negligence, noting that Tengswan had made it clear to the waitstaff that she had nut and dairy allergies. So this is a tragic story to begin with, right? That you have somebody with allergies. You have, at least as described in the lawsuit, a person and their spouse that is trying to identify potential allergens at this restaurant that they've gone to. And we're not going to go into the lawsuit itself because we're really more interested in Disney's defense here. But they claim that they talked to waitstaff, and the waitstaff talked to the chef, and they made sure that there were no allergens. And then when they got to the hospital, even after administering an EpiPen, she still died, and the medical examiner found that there was elevated levels of nut and dairy in her bloodstream. So you can see this. Nobody's happy about this. And certainly the justice kind of instinct that we have as human beings, and let me make sure that I can increase the size of this for everybody, is that somebody should be responsible for something like this, especially if it is as described in their lawsuit. And one of the things I always say in Virtual Legality, and I say here on the channel, is that we should always take those documents as the tilted, biased perspectives of those that are advancing them, because that's how our adversarial justice system works, right? So we don't have to assume from our 30,000 foot outside view that everything they say is accurate. But if it is accurate, then this is a tragedy. Nobody wants this to happen to them, and it's natural to feel like somebody should be responsible. And it might be Disney, it might not. One thing that's interesting about this particular issue is that Raglan Road is not owned by Disney. Disney gets brought into this lawsuit as the landlord that is leasing the property at Disney Springs, which is a kind of strip mall, Universal City Walk type area in the Disney World Resort. And Disney leases it to this particular company that runs this restaurant, and then also includes reference to the restaurant on their website and says that they can serve allergen-free foods. And so one of the things that happens in the lawsuit that we will see is that this particular plaintiff representing the estate of the deceased says, I went to the Walt Disney website. They said they could have allergen-free foods at this restaurant. That's why I picked it. And then we went there and said, here are the allergies that we're concerned about. Can you go make sure that these allergens aren't in this food? And then my wife died, right? So they want to say, Disney, you represented on your website that they could serve allergen-free food. You are an agent of this particular company. It's a little bit more attenuated than this is Disney's direct restaurant that they're operating, for instance, in the Magic Kingdom or somewhere else. And so that's its own level of difficulty with the lawsuit. And then Disney wants to get it kicked out, not just because of the Disney Plus arbitration that we'll see in just a minute, but also because the Disney Plus arbitration provision applies to things like their website. And the only way that they get dragged in is by virtue of the representation that they make on their website. And so it's a little bit stronger of an argument than it appears from these headlines. It's also still not a great argument. And we're going to talk about that as well. I did want to point out, this is the headline I highlighted in the thumbnail. Disney wants NYU doctor allergy death suit tossed because of widower's Disney Plus subscription, which is crazy, right? It's a crazy headline. It's why I highlighted it. It's why I wanted to talk to you about it today. But I did want to highlight for you the use of the word tossed, because I think if you're not a lawyer, if you don't know what's going on because you're only reading the headline, you're not reading the article, then you might not realize that Disney isn't trying to get out of liability entirely for this. They're trying to move it to arbitration. which is a different mechanism for dispute resolution in the United States and other countries. It says instead of the public court system, we can go to a private arbitrator, and that arbitrator is going to be invested with the same powers as a judge, and you agree to abide by them from a legal perspective insofar as we can enforce a decision against you in court, and the courts will abide by that. And we can go to arbitration instead of a public court system. So yes, they are trying to get it removed from court. That is accurate. And so I don't think that this is inaccurate. I don't think this is a lie. I think this is just kind of a technical misrepresentation a little bit, because it makes Disney look as bad as possible in headline form when they are trying to remove it to arbitration, not get it completely eliminated from any potential liability that they might have. And if we get into the article, we can see Disney is claiming the $50,000 suit. I don't think it's a $50,000 suit. It's more than $50,000. That's why it's not subject to small claims court. But again, that's why we do it in headlines. We talk about what the media reports. Should be moved out of the courts because Piccolo, that's the plaintiff, agreed to arbitrate all disputes with the company when he first signed up for a 1-month trial of the Disney Plus streaming service back in 2019. Court documents charge. And yeah, that's another aspect of this, is that this is not even a subscriber to Disney Plus. This is a person that essentially said, oh, I get a free week to try Disney Plus and see if I like it. I signed up for it, and I declined the trial after it was done. Or I think the court papers actually say that he thinks he canceled the trial even before it was done. And their affidavit says basically that I can't find any charges for Disney Plus from that period. I didn't ever think that this would come up in this lawsuit. So it's not like I have receipts on this, but the bank account doesn't have any charges to Disney for Disney Plus. So I don't think I even went past the trial. And so that's part of this conversation. But certainly even for a trial, you're going to have to enter into some kind of terms of service for that particular service as provided to you. And this is another kind of wake-up call warning to read through the important terms of those terms of use and license agreements that you get when you are entering into those particular subscriptions. And the same goes for video games, right? I joke in this space about the fact that the Crash Bandicoot or Crash Team Racing from Activision had, I don't even know, 50, 60, 70 pages of terms of service for this racing around as a cartoon Bandicoot game. And at some level, you can read those and say, there's very little possibility that this game is going to result in liability that I'm going to need to worry about these terms for. But when you've got a very aggressive company like Disney here trying to apply them to things like a wrongful death suit, you can start to worry, and I think justifiably so. So Piccolo's attorneys, that's the plaintiff again, have slammed Disney's latest motion as preposterous and outrageously unreasonable. In the May 31st motion filed in Orange County, Florida Circuit Court, Disney argued that the Disney Plus subscriber agreement Piccolo signed years earlier on his PlayStation called for any dispute, with the exception of small claims, to be resolved by individual binding arbitration. And in fact, we will see that they do claim that. This is a legitimate description of what Disney has claimed. And as I said earlier in this video, one of the things I would point out from a kind of real politics strategy standpoint is that, as I put in the description of this video, you do have to decide whether you should do something, not whether you just can do something. Now, it's the lawyer's job to go through a contract, go through an issue like this and say, well, we could possibly advance this defense. But by the time you've advanced a defense in a motion, and it hasn't even been judged upon yet, and it gets covered in the New York Post, it gets covered in other places that we'll talk about, then you've probably made a mistake, because the bad PR here is likely to be worse than even if you would succeed on getting this arbitrated. And I don't think you are likely to succeed on that motion in the first place. So a lawyer that finds this and says, you could advance this argument, should say, this is a risk. It's unlikely to be upheld. This is not likely a winner for you. And if it gets picked up by the media, it could look really bad for us. And as we saw in our own chat, have people that say, well, I'm second guessing whether or not I should have Disney Plus at all, or whether I should sign up for it in the future, because if Disney's going to act like this, I don't really want to be involved with them. So that being said, let's take a look at their document. So this is defendant Walt Disney Parks and Resorts US is moving for an order compelling the plaintiff to arbitrate all claims and staying this action pending arbitration. So outside of legalese, we want this out of court. We want this stayed. We want this court action stopped, and we want to go to an arbitrator instead of court. So yes, they want to get it quote unquote tossed from court, but not killing the possibility of liability to this individual. Instead, just moving it to an arbitration procedure instead of a court procedure. So This case involves an allergic reaction the decedent allegedly experienced after dining at a restaurant called Raglan Road Irish Pub and Restaurant, located in Disney Springs. Raglan Road is owned and operated by defendant Great Irish Pubs Florida, Inc. WDPR leases the property to Great Irish Pubs. The complaint alleges an agency relationship between landlord and tenant, that the landlord should be responsible for something the tenant did, right? In order to find these other deeper pockets, in order to find somebody else that could potentially be liable for your spouse's death, you try to make these associations to get them on the lawsuit. But the only facts supporting this theory are representations about Raglan Road's allergen-free food on the Walt Disney World website. Piccolo alleges that he relied on the website in choosing to dine at Raglan Road. But Piccolo ignores that he previously created a Disney account and agreed to arbitrate all disputes against the Walt Disney Company or its affiliates arising in contract, tort, warranty, statute, regulation, or other legal or equitable basis. This broad language covers Piccolo's claims against Walt Disney PR. So just to shorten this, and I think it's important to note that when these quotes are used, that's quoting the contract, it's quoting the terms of service that we're talking about here. And there are spaces between these quotes that we will find out to be significant in what Walt Disney is eliding, what they're skipping, in what the language actually says in their terms of use. And we'll get that in just a minute. But they say, you've agreed to arbitrate all disputes against the Walt Disney Company or its affiliates for anything, for any reason, by signing up to that Disney Plus free trial. And so you can't bring a court action. You can't be seen by a jury of your peers on this particular issue because you once signed up for Disney Plus, which certainly on its face is questionable, right? The reason this is a headline in the New York Post, the reason this is a headline in other places is because when you look at this and you look at what Disney is arguing, it seems crazy. And when you get to the place where it seems crazy, it might well be crazy. And that's one of the things that I think Disney's going to run up against here is that the defense is going to call this, or the plaintiff is going to call this unconscionable, an unconscionable application of this. And whenever you can say things like this should shock the conscience of the court, lawyers love to say that kind of stuff. And we will see that the plaintiff will, in fact, use that language here to say that this is ridiculous. In November 2019, Piccolo initially created a Disney account through the Disney Plus website. Immediately above his application was a disclosure notifying Piccolo that by clicking agree and continue, you agree to our subscriber agreement. The terms of use, which were provided with the subscriber agreement, include a binding arbitration clause. The first page of the subscriber agreement states in all capital letters that any dispute between you and us, except for small claims, is subject to a class action waiver and must be resolved by individual binding arbitration. The subscriber agreement also states in the same font that when you create a Disney Plus or ESPN Plus account, you also agree to the Walt Disney Company's terms of use, available at www.disneytermsofuse.com, and at the end of this agreement, which govern your use of Disney services. The terms of use include an arbitration clause in Section 7 titled Binding Arbitration and Class Action Waiver, which applies to all disputes, including those involving, now this is interesting, this is actually seemingly erroneous. Now I'll talk about why it's seemingly in just a second, but this is a capitalized D in the document we're going to look at, and that means it's a defined term. And by not capitalizing it here, it's a bit close to a lie. I would never accuse anybody of filing a legal document that is in fact a lie, because my ethics bar prevents me from accusing other lawyers of doing things like that. But this does seem to be, at bare minimum, a very advantageous mistake. WDPR is an affiliate of the Walt Disney Company. The binding arbitration clause provides in relevant part that neither you nor Disney DTC will seek to have a dispute heard as a class action or private attorney general action or in any other proceeding in which either party acts or proposes to act in a representative capacity. That's the waiver of class actions. No arbitration or proceeding can be combined with another without the prior written consent of all parties. Again, the waiving class actions. You and Disney and DTC agreed to arbitrate as provided below all disputes between you. So this is a small d dispute in this particular language, including any related disputes involving the Walt Disney Company or its affiliates that are not resolved informally, except disputes relating to the ownership or enforcement of intellectual property rights. Dispute, capital D for defined term, includes any dispute, action, or other controversy, whether based on past, present, or future events between you and us concerning the Disney services or this agreement, whether in contract, tort, warranty, statute, regulation, or other legal or equitable basis. And I highlighted that in red because you can see when you have these provisions, especially in a contract of adhesion, click wrap type setting, you assume that it applies only to the thing that you are entering into an agreement about, right? So if you're signing up for Disney Plus, yeah, I agree to arbitrate problems I have with Disney Plus. If somehow that hurts me, if it lights my PlayStation on fire, if it does something like that, but I'm not agreeing to arbitrate wrongful death issues at Disney Springs in Florida. And they seem to skip some of this, the concerning Disney services. Now, they say they define Disney services as sites, software, applications, content, products, and services, including WDPR's website. So they're trying to get out of that representation that they are being accused of making as regards non-allergens in the food. But it's a weak argument as it stands, and we'll see that it's even weaker in other places in the document itself. So let's go on a little bit further. First, the Disney terms are a valid and enforceable click-wrap agreement, which required Piccolo to assent by selecting agree and continue before proceeding. I do want to talk about contracts of adhesion and click-wrap just a minute. I know people come into this particular channel and in my comments often and says, terms of use, EULAs, whatever they are in any particular context, they don't go past the law. The law still sits on top of them, and you can't agree to certain things. And certainly other jurisdictions outside the United States have different rules on how these things can be applied. But as I've said in Virtual Legality and on this channel, in general, the United States keeps a rule that says we are going to honor the validity of contracts entered into by parties, and we're going to accept things like end-user license agreements as being a meeting of the minds of the two parties that are entering into them. And so in this particular case, you've got a click-wrap style agreement, a terms of use of subscriber agreement, whatever it winds up being called, in the context that someone does have to say agree and continue to. That's mostly going to be held as valid overall in most states of the United States. Now, there are still ways you can get into trouble that we'll see referenced by the plaintiff's response, by hiding things that are important, by not describing them properly within a document like that. It is important to remember that as a contract of adhesion, that is to say a contract that we're not negotiating, right? This is offered to you by a party. You don't get the right to redline it. You don't have the opportunity to say, I'm okay with this, but not this, or maybe we change the wording a little bit here, like we do in a business-to-business context. This is offered to you on a take it or leave it basis, that is going to get less kind of discretionary court adherence than something that is a fully negotiated contract, right? A court is going to look at that and say, well, we might read this against you, or we might say that this is too hidden in this particular document because this is a contract of adhesion that you've offered to the party. And that's one of the things we'll see the plaintiff argue. But what we won't see argued is that it's just strictly not applicable. The plaintiff might do this in their document, suggest that it's more of a browse wrap agreement, meaning it's something like the terms of use on the bottom of a website that you just kind of pass by. But to the extent this is true, this is going to be upheld as valid in most circumstances in the United States. Doesn't mean that their reading of it is correct, but it does mean that the contract itself is probably applicable to this particular relationship. Whether or not it's applicable to the wrongful death suit is another ball of wax entirely. So there is another aspect of this that is perhaps even more important with respect to arbitration uniquely. So in the United States, there is federal law called the Federal Arbitration Act that basically says we are going to favor arbitration whenever we can. And so if parties want to enter into arbitration agreements, we're going to find them to be valid in most instances. And the reason for that is because courts get overwhelmed with the cases that they already have to handle. So the United States decided years and years ago, this is not a new act, that they would say anybody that wants to arbitrate things, we're in favor of that, move it out of the court system, and that's good with us. So there is an overriding kind of federal rule of interpretation that says we're good with arbitration if it's there. And then in this particular instance, Disney is going to claim that whether or not something is arbitrable, whether or not a dispute is subject to arbitration, is a question for the arbitrator, not the court system. So they say before analyzing whether Piccolo's claims fall within the scope of the arbitration clause, the court must decide whether the parties delegated the responsibility to the arbitrator. When clear and unmistakable evidence shows that the parties agreed that an arbitrator would decide issues of arbitrability, such provisions must be enforced. And they quote another case. It says parties can agree to arbitrate gateway questions of arbitrability, such as whether the parties have agreed to arbitrate or whether their agreement covers a particular controversy, which is true. And you see that this becomes a tricky situation to the extent that this is true in this particular contract, because if you agree to an arbitrator will decide whether this is arbitrable, then Disney is probably right on a kind of technical procedural basis to say if this is remotely applicable to the situation, it's not the court's decision to decide, it's the arbitrators. And so this should be stayed because we should go ask the arbitrator. And if the arbitrator kicks it out at that point, well, fine, then we go to court. But this is wrong to do as the first step. And certainly that's a problematic argument from a procedural perspective for potential plaintiffs, because there's no reason that a plaintiff in this situation would know that signing up to a Disney Plus trial, however many years back, should subject them to arbitration and go get that done first before they have the right to a jury trial. So that's an issue in and of itself, but that's what Disney's raising. And it's not an argument that can be just thrown out because of the breadth of the Federal Arbitration Act, and because there is a bit of language in this particular document that says questions of arbitrability go to the arbitrator. So that's, in my opinion, a better argument here than some of the other stuff that they've raised. They say the Disney terms delegate to the arbitrator, not to a court, exclusive authority to resolve any dispute relating to the arbitration clause's interpretation, applicability, or enforceability, and whether any part is void or voidable. It is hard to imagine a more expansive delegation clause, and that might well be true, but there is still a kind of threshold question as to whether an arbitration agreement was even entered into here with respect to this issue at all, which sounds like applicability, right? But a good plaintiff, a good lawyer can argue that it's essentially a threshold question even getting to that point. Otherwise, having a provision like this in any contract could just allow you to claim arbitration as a first step for any dispute. And that's not really how the Federal Arbitration Act or the court system is set up. So we'll see those arguments as well. Because the term dispute includes claims related to our website, Piccolo's negligence and agency counts fall within that arbitration agreement, claims Disney. And we didn't waive it, even though we answered some of the documents here. That'll be a fight that we're not going to go into in too depth here in Hangouts and Headlines. The court should stay the proceedings pending arbitration because we got to go talk to the arbitrator. And that's Disney. It's not a bad document from a legal perspective. They make their arguments as well as they can make them. I just think from a business and strategic perspective, this probably isn't terribly wise to make, as we saw from the way it's handled in the news and the fact that this isn't likely to win. Why isn't it likely to win? Well, let's talk about the canons of contract construction. And this is from, I believe, the University of Houston Law School that I found online. This is essentially the notes form of a book that you could buy right now if you're interested in interpreting contracts or statutes or anything else, from ex-Supreme Court Justice Antonin Scalia and Brian Garner. And this is about reading contracts and understanding how a court is going to read them. And one of the things that's the most important is words are to be understood in their ordinary everyday meanings unless the context indicates that they bear a technical meaning. And the text must be construed as a whole, right? That you have to take context for whatever is around the provision that you're looking at, what the parties intended, because a contract is intended to be a meeting of the minds. It means to communicate between two parties what they are agreeing to. And to the extent it doesn't do that, or it's ambiguous on that point, a court is going to have issues enforcing it. So those are important kind of canons of context. If possible, every word and every provision is to be given effect. None should be ignored. None should be needlessly given an interpretation that causes it to duplicate another provision or to have no consequence. Every word should mean something. The text must be construed as a whole, and we have to use ordinary meanings because we're concerned about what reasonable people think about these things, right? Or as this is described at the end, the absurdity doctrine. A provision may be either disregarded or judicially corrected as an error if failing to do so would result in a disposition that no reasonable person could approve of. So, said another way, if no reasonable person in America thinks that signing up for Disney Plus should force them into arbitration for a wrongful death suit based on allergens at Disney Springs, then that's the kind of thing that the court should look at and say, no, that's some nice attempts at lawyering, but that's not the way that this contract is going to be read. Reasonable minds are still the most important aspect of legal enforcement. That reasonability standard is how we look at things like contracts and statutes. And it is what's going to ultimately lose Disney the case here, I think, because if we look at the subscriber agreement, and I do want to give a disclaimer here that this is as updated this year, because I couldn't use the Wayback Machine to go and find the version that would have been applicable in November of 2019. It just wasn't working for this particular page. But we can assume, based on what we saw in Disney's motion and what we'll see in the plaintiff's motion in response, that this is primarily the same on the questions that we care about as of 5 years ago. So one of the things I wanted to highlight for you is that this agreement in full caps, so they want you to know this, you should read it carefully because it governs eligibility for and use of the services. So as we would expect, the way Disney frames this document, it's not about everything you could possibly do with Disney, the multinational entertainment company. It's eligibility for and use of the services. Now, what do they mean by services? Well, they describe the Disney Plus services, the Disney Plus website, the application, the video player and related software, associated content and other services, which is a bit broad, but probably doesn't get you out of the Disney Plus website box, as we just discussed with the canons of contract construction, in any media format or channel now known or hereinafter devised. If they start sending you VR holograms, then that's still going to be covered if it's through Disney Plus. The ESPN Plus service includes ESPN Plus website, same kind of description, and the Disney Plus services and the ESPN Plus services are referred to together as the services. So when they say this governs your eligibility for and use of the services, they're talking about ESPN Plus and Disney Plus. Now, they do warn that any dispute between you and us, except for small claims, is subject to a class action waiver and must be resolved by individual binding arbitration. But this is a summary statement, so we need to know what dispute between you and us means. A reasonable person, I would argue, would generally say it means a dispute between you and us regarding the subject matter of this contract. And we will see that, in fact, they do define it that way later on in Section 7. Please read the arbitration provision in this agreement as it affects your rights under this contract. Where does it affect your rights? Under this contract. Binding arbitration and class action waiver. So let's go to Section 7. We got some scrolling to do, which is one of the reasons that they have that sentence up above to say, hey, this is subject to a class action waiver and arbitration provision, because they're worried that this might otherwise be seen as too far into the document to have people understand that this is, in fact, in this document. Please read this provision carefully. There may be instances in which disputes arise between us. Lowercase d, this is just a sentence kind of off on its own. You on the one hand and Disney Plus and or ESPN Plus on the other hand agree to resolve by binding individual arbitration all disputes, including any related disputes involving the Walt Disney Company or its affiliates, except for any claim within the jurisdiction of a small claims court consistent with the jurisdictional and dollar limits that may apply, and any dispute relating to the ownership or enforcement of intellectual property rights. So this one here, from a legal perspective, is included because they don't want to arbitrate IP infringement issues because they need a court to enforce those against you. And there are issues with an arbitrator deciding these things and then getting them enforced in court. So that's included for their benefit. This is included just for the small claims side of things. But again, we see this capital D disputes. Now, a couple of things I note from a legal perspective. One, the agreement to arbitrate is between you on the one hand and Disney Plus and or ESPN Plus on the other. So it can cover disputes that are with the Walt Disney Company, but only in respect of arbitrating between you and Disney Plus or ESPN Plus. Since they aren't parties to this particular lawsuit, you wouldn't assume that this applies naturally. Secondly, if we go and look at how dispute is defined, it includes any claim, dispute, action, or other controversy, a lot of legal language here, between you and us concerning the services. And what are the services? We just talked about. The services are Disney Plus and ESPN Plus. And so they want to use this kind of overly large language, any claim, dispute, whether based on past, present, or future events between you and us. And they don't want to give effect to concerning the services or anything like it. And they skip that when they make the claim in their motion. And I think that's going to ultimately lose them all of this. But that's because you have to read all the words as meaning something in this contract, as we just talked about. Then you waive class action procedures, etc. Now, there is going to be one fight because there's a kind of dispute between whether this subscriber agreement or the terms of use should apply. And they say that the terms of use were also agreed to. You see Disney terms of use here by virtue of this reference down here. Once available, by registering for the services without a pre-existing My Disney account, you are creating a My Disney account. Your email address and password for the services will be managed by My Disney. Your My Disney account is governed by the Disney Terms of Use, which can be found at disneytermsofuse.com. Now, that's essentially a database for keeping your email address and password for the services, and they want to apply what's in the terms of use separately, but they're not going to have a lot of success with that because it is buried, because it doesn't obviously apply to this situation, or certainly the situation of a wrongful death at Disney Springs, and we'll see that all in the plaintiff's response. But overall, I wanted to point out that Disney is, even in their motion here, which is aggressive lawyering at bare minimum, is skipping certain aspects of what's actually in the provision of the contract, which they're going to get called out on. And even if they weren't called out on it, a court's going to find those things when it looks at the contracts itself, and we'll see that in response. Further, I think it's a bad idea to bring this claim anyway, because you are going to get the coverage that they got on this and make people freaked out about both Disney as an entity and Disney Plus as a service. But here's the plaintiff's response to what Disney had to say. So, even if WTPR had not waived its rights, it is attempting to enforce an agreement that it never signed against a party who also never signed. So this is important, right? When you've got a contract, you can talk about third-party beneficiaries. You can talk about other parties that might have some interest in the contract itself. And we can argue that that happens in the provision that we just read regarding other Walt Disney entities and disputes that they might have with capital YU in respect to the subscriber agreement. But if you didn't sign it yourself, if you aren't a party to it yourself, it becomes difficult to apply in situations like the Federal Arbitration Act. And so they say, look, yes, it might cover disputes with other parties, but we don't have to arbitrate it with them because the only people we have to arbitrate it with are ESPN Plus and Disney Plus, as we just looked at. So that doesn't apply. Third, even if the court were to consider the substantive part of WTPR's untimely motion, so they're saying it was late, it is based on the incredible argument that any person who signs up for a Disney Plus account, even free trials that are not extended beyond the trial period, will have forever waived the right to a jury trial enjoyed by them and any future estate to which they are associated, and will instead have agreed on behalf of other survivors and the estate itself to arbitrate any and all disputes against any and all Disney entities and affiliates, no matter how far removed from the use of the Disney Plus streaming service, including personal injury and wrongful death claims. This is good lawyering. This is, you want to establish that kind of reductio ad absurdum. Look, court, if you are agreeing with Disney on this, and there are reasons that technically you might want to go in that direction, as we just talked about on this video, if you go in this direction, then this is what you are agreeing to. You are agreeing that anybody that signed up for a free trial of Disney Plus doesn't get a jury of its peers for anything up to including wrongful death. As it can be seen from the prior sentence, this agreement borders on the surreal. Even assuming that the estate is bound by an arbitration provision in the Disney Plus subscriber agreement with Mr. Piccolo, the terms of the agreement make it clear that Mr. Piccolo was only potentially agreeing to arbitrate claims concerning the Disney Plus streaming service. The Disney Plus subscriber agreement on its face establishes that there was no agreement to arbitrate injury claims against other Disney entities. And then some other arguments that we don't need to go into because that's not what we need to discuss right here. The My Disney Experience terms and conditions expressly provide that they will apply in the event they conflict with Disney's terms of use. Because of the conflict noted above, the My Disney Experience terms, which do not contain an arbitration clause, are the only terms which could arguably apply to this lawsuit, and plaintiff has complied with those terms by filing suit in Orange County, Florida. Finally, a valid agreement to arbitrate does not exist because the arbitration clauses upon which WDPR rely are unconscionable, right? So this is saying, look, even if we agreed to this in language that applies to this situation, the court should void it, essentially what we would say void for public policy, right? You can't have corporations doing this kind of thing. They can't get out of a wrongful death court case by having you sign up to their entertainment streaming service through your PlayStation. That's crazy, and the court should get in front of it and use their equitable powers, those powers that are outside of the strict black and white letter of the law, to say, no, this is unfair and we're not going to allow it. The Disney Plus account. Mr. Piccolo believes that he canceled the subscription prior to the expiration of the free trial because he has been unable to locate any charges associated with the Disney Plus account after the date of the trial. Plaintiff submits an affidavit in that respect. Importantly, by WTBDPR's own admission through the Morgan Declaration, so that was a different affidavit, the acknowledgement Mr. Piccolo allegedly agreed to by clicking agree and continue made absolutely no mention of the Disney terms of use and provided no hyperlink to the Disney terms of use. The hyperlink to the Disney terms of use was buried within the middle paragraph halfway down the first page of the Disney Plus subscriber agreement, which itself was a hyperlink on the Disney Plus registration webpage. So these are kind of nested agreements, right? So you've got the registration. I want my free trial of Disney Plus. Here's the subscriber agreement that we were just looking at. And in that subscriber agreement, there is a link to the terms of use, which probably looked a little bit different in 2019, but it was buried something like this. Governed by here, here's what it applies, Disney terms of use. And they say, well, that's 2 steps removed from what we're actually doing when we file for a Disney Plus subscription. So you're not actually going to enforce that against us. Mr. Piccolo simply did not agree to the Disney terms of use on behalf of himself, and certainly not on behalf of his wife or her estate when he clicked agree and continue on the Disney Plus registration webpage. Furthermore, had he agreed to be bound by the subscriber agreement, Mr. Piccolo would clearly have only been agreeing to arbitrate his own individual claims arising from his use of the Disney Plus service. The arbitration provision in the Disney Plus subscriber agreement specifically limits the definition of dispute to controversies concerning the Disney Plus service and the Disney Plus subscriber agreement. So you see, this is language that is not exactly the same as what we see in 2024, but it is similar in scope. So the language that's highlighted here is concerning the Disney Plus service, ESPN Plus service, or this agreement. This was changed over to what we just looked at with the capital S services, which is then defined at the top of the agreement as it stands right now. There is simply no reading of the Disney Plus subscriber agreement, the only agreement Mr. Piccolo allegedly assented to in creating his Disney Plus account, which would support the notion that he was agreeing on behalf of his wife or her estate to arbitrate injuries sustained by his wife at a restaurant located on premises owned by a Disney theme park or resort from which she died. Frankly, any such suggestion borders on the absurd. And I tend to agree with this particular plaintiff's lawyer here. And then they have some description of the various other apps that exist. If you've ever been to Disney or Disney World, you know that they have a bunch of different apps that apply to a bunch of different situations. They have a cruise app. They have a theme park app. They have other things that have gone and come when they change how their magic bands work. Disney is not a tech company, and it shows when you do visit them. And I do like Disney, but they have tech issues. WTPR desperately clings to Mr. Piccolo's purported consent to the Disney terms of use in November of 2019 because the My Disney Experience terms and conditions he allegedly consented to in 2023, which would be more directly applicable to this vacation, presumably, do not contain an arbitration provision. While plaintiff maintains that none of Disney's terms and conditions apply to the claims raised in the wrongful death action, that's kind of preserving the state of argument from the lawyer, it should be noted that the only terms which could even arguably apply would be the My Disney Experience terms and conditions because they govern the use of the My Disney Experience website and or the My Disney Experience mobile application. So look, you're trying to drag Disney Plus into this, but the thing that's closest to you doesn't have the provision that you need. So you're doing some aggressive, hard lawyering, and while that's wrong, it's even doubly wrong in this situation. And then they point out that there are ambiguities between the way these various apps run, talking about whether you need to bring suit in Orange County, Florida, whether you need to bring arbitration in Manhattan, New York, or Los Angeles, California. And that if you read all these together in the way that they're presented by Disney, that they're ambiguous and you wouldn't know where to file a lawsuit at all. So the court should just essentially honor the client's request to have the suit here because he's trying to comply with what he thinks is applicable and Disney's being crazy. Argument. Walt Disney Public Parks waived its non-existent right to arbitration through its voluntary participation in these proceedings. So as we saw, Disney's initial motion for this was in the May. And this only got reported on when somebody picked up this response from the plaintiff here in August. But when Disney filed that motion, they had already done some things in the case. And the argument here is that Disney has waived its ability to push something into arbitration because it's just trying to run the bills up for the plaintiff. Second, Walt Disney Public Parks is attempting to enforce an alleged arbitration agreement against the estate of Tang Swan Canuckborn, despite the fact that neither are signatories to that agreement. So we talked about that same, you have to be signatory to the agreement. You have to have signed something to be bound by it. In the case of Walt Disney Company not being a party to the Disney Plus subscription agreement itself. And this is similar for the fact that the estate of this deceased is not a party to the contract. So that's the argument here. I don't think this is a winner because I think they probably signed on behalf of various members in the party. On the My Disney Experience side of things, but on the Disney Plus side of things, I can't actually tell you whether it would work. I don't think it's their strongest argument, certainly. Third, assuming that an arbitration agreement consented to by Mr. Piccolo in his individual capacity did bind his wife's estate or apply to his recovery as a survivor, there's no valid agreement to arbitrate between WDPR and Mr. Piccolo. So this is the reverse that we just talked about. Walt Disney Public Parks is not a party to the agreement. Now we have to talk about that arbitration is decided by the arbitrator argument. There's simply no reading of the Disney Plus subscriber agreement, which would support the notion that Mr. Piccolo agreed to arbitrate claims arising from injuries sustained by his wife at a restaurant located on premises owned by a Disney theme park or resort, which ultimately led to her death. In making this argument, plaintiff is not requesting this court to determine whether an arbitrable issue exists, which RDPR contends must be determined by the arbitrator pursuant to the agreement. Oh, really? What are you asking for? Plaintiff is merely citing the agreement's definition of dispute for the proposition that there was no agreement to arbitrate any claims other than those arising from the Disney Plus service. Now, the issue the plaintiff is going to have here is that there is at least a colorable claim that what you're talking about still is, if we're going to argue definitions, whether something is arbitrable or not, applicability of an arbitration provision. And as unfair as it seems, and indeed I agree that it seems unfair, it might be the case that this should be adjudicated by an arbitrator so that the arbitrator can kick it out, and that this argument should be made to an arbitrator to kick you back to court, essentially, rather than to the court doing it in advance. And a judge might be conservative enough to say, no, I'd rather have it go to the arbitrator to get kicked back to me than to make this decision on my own and have it be an appeal later on. So I can't speak for what's in a judge's mind. I think this is a pretty weak argument from Disney. But a really conservative, small c, not politics here, but someone that's really risk averse in that judge's seat could say, well, okay, you make a good point that it shouldn't be arbitrable. Maybe you should make that point to the arbitrator instead of to me. And that might be something where Disney winds up winning on this particular question, even if it feels as unfair as I've already described in this video. And then we have a description of click wrap agreements and browse wrap agreements. Florida courts have recognized two main types of internet contracts: click wrap agreements and browse wrap agreements. A browse wrap agreement occurs when a website merely provides a link to the terms and conditions and does not require the purchaser to click an acknowledgement during the checkout process. If you've ever wondered why you're playing a video game, you're on a website, and you have to scroll through all the terms before you can accept or other things, these are the reasons why, because the courts have determined that if you make it too passive or too unknown what the terms of service are, then a plaintiff can claim they never read them, they didn't understand them, they weren't bound by them. And so you have these various mechanisms that are used by websites to say, no, you have to assent, we're going to show it to you, we're going to make you look at it, and those kinds of things. If a hyperlink that is found at the bottom of a web page or which is placed beneath a purchase or subscription button have been found by courts to be too inconspicuous to provide inquiry notice, it's the notice of asking a question about what I might be bound to, then the Disney terms of use, which were not referenced on the Disney Plus registration page, nor supplied in a conspicuous hyperlink, but were instead buried within the supplied hyperlink to the Disney Plus subscriber agreement, certainly cannot provide notice. So we want to be limited to the subscriber agreement, which we looked at, and we don't think the terms of use apply. I think that's all I wanted to grab here. Maybe I have one more here. A valid agreement to arbitrate does not exist because the agreements are procedurally and substantively unconscionable. Okay, so this is the unconscionability. This is the void for public purpose kind of notion. Unconscionable and unfair arbitration clauses, like unconscionable contracts, are unenforceable. They are, in fact, a form of unconscionable contract. To support a determination of unconscionability, however, the court must find that the contract is both procedurally and substantively unconscionable. What do you mean by that? The procedural component of unconscionability relates to the manner in which the contract was entered, and it involves consideration of such issues as the relative bargaining power of the parties and their ability to know and understand the disputed contract terms. Procedural unconscionability requires consideration of whether there was an absence of meaningful choice on the part of one of the parties. For example, the court might find that a contract is procedurally unconscionable if important terms were hidden in a maze of fine print and minimized by deceptive sales practices. Now, in and of itself, the arbitration provision is not unconscionable. They have the right language up front that says, hey, you're subject to an arbitration provision, and all of this would hold, except for if you intend to apply it to things like wrongful death when you visit us in Florida, it might be unconscionable by nature of the fact that you didn't highlight that you were meaning to apply it in that way, right? So that's one of the arguments they're making here. In contrast, the substantive component focuses on the agreement itself. As the court explained in this case that we're going to reference in Florida, a case is made out for substantive unconscionability by showing that the terms of the contract are unreasonable and unfair. A substantively unconscionable agreement is one that no man in his senses and not under delusion would make on the one hand, and as no honest and fair man would accept on the other. So this is a version of what we talked about when we were looking at the canon of construction, which is to say we're not going to read agreements to be crazy, right? We're not going to hold the provision to be applicable when it would result in a disposition that no reasonable person could approve of, because that can't possibly be the meeting of the minds. If a reasonable person wouldn't think that it does this, we're not going to read it that way. And so that's what this particular argument is making under Florida law, rather than just kind of general contract principles. And they make their case here. They do note that this is a contract of adhesion. They also note in footnote that that doesn't make the case for them. Contracts of adhesion are valid in Florida, but there are other aspects of this particular application that go towards unconscionability. That's what their footnote says. The binding arbitration provision in the Disney terms of use purports to apply to any dispute a consumer has with any of Disney's affiliates or subsidiaries for all time. The notion that terms agreed to by a consumer when creating a Disney Plus free trial account would forever bar that consumer's right to a jury trial in any dispute with any Disney affiliate or subsidiary is so outrageously unreasonable and unfair as to shock the judicial conscience. Like I said, every lawyer that's been to law school is looking for a reason to use that particular phrase because that's a fun one, and it does tend to wake up the court. So they want to say it shocks the judicial conscience. I tend to agree, even though I do think they have at least a hook to hang their hat on the arbitrability question, which we can see better if I can get to it here. Unfortunately, the page that Disney uses for their contracts doesn't allow me to highlight them. So I have to remember exactly where it is buried in these provisions, which is its own problem, right? So I'm not going to find it on the fly. It's not that important. It is in here that says the arbitrator is going to decide on the arbitrability of the contract. but we'll leave it at that. Shocks judicial conscience. WDPR is explicitly seeking to bar its 150 million Disney Plus subscribers from ever prosecuting a wrongful death against it in front of a jury, even if the case facts have nothing to do with Disney Plus. So again, this lawyer is doing a good job of highlighting, if you go with them, even if they have some technical aspects that you might be moved to undertake, then this is going to embolden Disney and every other tech company to say our arbitration provision prevents you from doing anything related to anything that we do or any of our affiliates do. And when we're talking about big multinational tech companies, that's going to be a big problem, Your Honor. So don't do this that way. And I think that's a good argument. It's an argument to fairness. It's an argument to justice. And I think this is a well-lawyered document. I was worried before I got into these that we'd see a kind of crazy set of legal documents on one side or the other. And I think they're both kind of well-drafted. I just think Disney's actual argument is close to beyond the pale. So with that said, how does everybody else feel about this particular case, this particular bringing up by Disney? And how are you all doing on any other topic that you want to discuss here before we leave? Yellow Spoo says, I'm a big fan of justice. Yeah, I would think that justice is a good thing that most people can agree on. Having been on Twitter for as long as I've been on it, I don't say that anything can be agreed to by everybody, but in general, justice, something to be pursued. Absolutely. Chris says, I'd go with the plaintiffs. They make the better argument. Plaintiffs say, hey, this is not what it was intended to do. We've got all this language in the contract that they skipped, Your Honor. And if you let them do this way, they're going to say nobody can bring a case against us for killing anybody because you once signed up for Disney Plus. That's crazy. Runkle says, I'm not allowed to have an opinion about this case. I gave up that right when I signed up to a trial account 20 years ago. Yep. Sorry, Runkle. Not only did you sign up for one, you signed up for it before it existed. I mean, if you're that big of a Disney fan, there's nothing I can do to save you, my man. But I'm glad to have you here, Ian. It's good to see you. Kat says, Disney gets no respect. They're the Rodney Dangerfield of streaming services. Kelly C says it feels slimy on Disney's part. It definitely does, right? Let's take a step back from the legal aspects and even from the media aspects. It feels slimy. It looks slimy. Those headlines make you feel bad about Disney. That should be taken into account in the boardroom before you ever allow this to go out there. And I will say, generally speaking, motion practice, where you're looking for dismissals and moving to arbitration things, they don't raise media headlines, right? And Disney got away with it in May. This was not picked up in May, as far as I could tell. This was picked up when the response was made by the plaintiff. So maybe they felt emboldened a little bit. But yeah, if you're Disney, you have to be thinking about, how does this actually look to the people that we want as our customers? And I think it does look slimy. Pixie Design says Disney is just ridiculous. Safira says throw the mallet at Disney. Eva says I have secondhand embarrassment for the Disney lawyer. The Disney lawyer's job, honest to God, the Disney lawyer's job is to say, here are some arguments that we could make. And I don't think their arguments are insane, except for the fact that they do cut out some of the definitional terms. And I find that to be a little bit further than I would go in terms of aggression. But skipping that, saying that an arbitrator should decide this question, that kind of thing, is at least justifiable enough to say you could bring this claim. And then the Disney business people have to say that's too aggressive. And the fact that they didn't is suggestive of how Disney is operated as a business right now. And you can take that however you want. But that's where my concern would be in terms of being a customer of Disney's, which I am and was very recently. Britt says, I feel the same as my question before. I cannot see how this is Disney's way. It doesn't feel good to support a company that does these kinds of things, certainly. And I think that the plaintiff's case overall is probably a little stretched. You heard me say that when I was talking about how the terms were described, which is to say he's bringing Disney in because Disney has all the money. Disney's the landlord of this company and says that they offer allergen-free food. That probably doesn't make Disney specifically liable in this particular instance. But the fact that Disney is worried enough about liability that they go with this level of aggression on something that I think is already a bit of a stretch to hit their pocketbooks says something about the way their company is operating right now. Chris wants to thank whoever gifted me a membership. I think Brentwood Chic gifted some memberships earlier in this video. So I think probably it's Brentwood, but if I missed somebody or if I'm getting that wrong, let me know. Kirsten says, if this is ruled in Disney's favor, we're all in big trouble. Honestly, I think if Disney is to win this motion, it's going to be on the basis of arbitrability, and it's going to be kicked to an arbitrator and almost instantaneously kicked back to court as non-arbitrable. So I don't think we're actually in that big of a trouble, but certainly the plaintiff doesn't want to do that. That's extra money, it's extra time, and you might lose an arbitration. So they're trying to avoid that circumstance. Kirsten says, what else have I signed and I don't know? I think no human being could possibly know all the terms that they've signed up to with things like websites and apps at this point. HP says Disney just started to look better after the horrible year they had last year, and now they've ruined it. Well, this is a bit of a niche topic, so we'll see if a lot of people pick up on it, but I do think it looks bad for them, certainly. Runkle says the House of Mouse needs to think of the PR implications of this argument too. They really do, right? Like, they have a limited chance of liability in this case to begin with. This is a big time stretch for them to win and get kicked out into arbitration as it stands. So you've got a low exposure risk. You've got a high chance of PR negativity coming from a motion that you probably won't win. And this is what you get. You get a Hangouts and Headlines about you. Nobody wants that, right? Disney is sick of being covered on this channel, I am sure. But there you go. Pixie Designs, I think the biggest thing here for me is that signing a contract that you were no longer actively in should not envy you from legal action. That's unrelated to the contract you no longer have. I don't know envied there and what you mean, but I do agree that in general, the contracts that you enter into shouldn't be broadly applicable to other aspects of your life well past the contract end date. But that's one of the reasons why when you see a subscription agreement like the one you saw, Disney does say the right things in saying it applies to the services. It applies to eligibility for the services. It applies to Disney Plus and ESPN Plus if you also sign up for that at the same time, but not in general for you visiting Disney Springs. Emily, I don't agree with Disney's position and it's bad PR, but not sure how much Disney is really at fault here for the incident just being the landlord, but they have the dollars. Yes, I agree with that. I agree that they were pulled in here as the deep pockets in this particular situation. I don't actually think they have a high level of exposure, but I am not general counsel for the Disney Corporation. And so I do think that you need lawyers and legal counsel to work with the business folks and understand when something is bad to bring in a legal action, not because you could potentially lose on it, but because it looks bad even if you win. Zealous Spoo says, I mean, good for the lawyer for attempting it. That's the lawyer's job, but it's not a good look. Corporate should have realized that ahead of time. Agreed. Katerina Gadecki says, Disney owns so many things now, it would probably be difficult to find somebody who has never agreed to any of their terms ever. Unhappy face emoji. Yeah, it probably would, right? Like, if you entered into a contract with some kind of Fox streaming service 2 decades ago, it's probably under Disney's purview and assigned to Disney by now. So yeah, there's a lot of things that you could be concerned about if a company is going to try to enforce its contracts like what we see in this case. The House of Mouse should be changed to the House of Weasel, says New Tricks. Well, you know, that's technically an ad hominem attack, but it is a corporation, so it's okay. Kirsten Factor, so true, Hoeg. Thank you so much. I don't know what it was that I said that was so true, but I always appreciate the well wishes and kind words. San Medina says, becoming a channel member to Hoeg does not have an arbitration clause. Not to me, certainly, although I would say, like I do for anybody, that YouTube has its own clauses and it has some mercurial applications that it has used for its own rules, as you probably well know if you followed anybody on the legal side of things and how people get strikes and don't get strikes in YouTube land. So definitely read through all of your terms of service if you can for things like YouTube and otherwise. But that said, I don't intend to arbitrate or sue any of you. So please do. If you are at all inclined, support the channel with a membership, a super chat, or otherwise. I really appreciate it. Likes are great. Comments are great. I love having these conversations. I'd like to do it more often. Knoxville Buckeye says, even if the Disney Plus terms applied, the dude never continued his Disney Plus account. Someone else mentioned it earlier, but wouldn't that make it null and void? No. So if you look at most of the contracts that you enter into, they'll have something called a termination clause. And the subscription agreement, I believe, says essentially terms that by their nature would survive, will so survive. Let me see if I can find it. And that's pretty normal for these. So if you agree to arbitrate a dispute, again, because this is only supposed to be related to your use of Disney Plus, so it shouldn't naturally apply to anything else. If you had an issue with Disney Plus after your contract ended, you'd still have to arbitrate it. If Disney Plus, for whatever reason, had some kind of weird code that was running in it that turned your PlayStation into mush, after you had exited your contract, you'd still want to be protected by some of the warranties and reps here, and Disney would still want to have to take you into arbitration. But it does have a termination clause in here somewhere. Survival. The provisions of this agreement, which by their nature should survive the termination of this agreement, shall survive such termination. So anything that relates to this contractual relationship is going to survive. And that's normal. You're going to see a provision like this in almost everything that you sign up to online. So that's the nature of these things. I've written provisions like that. I like to put things in a more deliberate way, mentioning which sections I say survive, but it is natural for website terms and app terms to have that kind of language. It says, look, obviously dispute resolution is going to have to survive this contract because we could have a dispute after the fact. Brentwood Sheik says, great to have you back, Hoeg. Looking forward to more Hangouts and Headlines. I'm looking forward to doing more videos in general. I have to find the right place and the right time. And I don't want to take another month off of this, but I appreciate all of you that have been so kind with my posts and saying, hey, I'm not making videos right now. And I apologize for that. I do appreciate it. And I want to be back here more often, certainly. Britt, thank you for so many generous super chats today. Whoever signed off on this from the C-suite needs to be looking for a job. Even if it costs them $250,000 to settle it, it's still less expensive than this nightmare PR. Disney with unfavorable news coverage again. I agree, Britt. I think that's the nature of this. Like I've been a lawyer in big companies and said, hey, you could advance this argument. You could do this and this and this. And the business people will say, no, that's not worth it, even if we want it. And that seems to be what should have happened here in this particular Disney case, because you do have headlines like the one we highlighted here, and you have a lot of people reacting like, what in the heck is that crazy thing? And I think that's justifiable. Kelly Godley says, we have missed you and love having you back, Hoeg. I am glad to be back. Thank you so much. Runkle says, hey, just so you know, a wrongful death involving a doctor isn't going to be a $250,000 case. Yeah, it's possible. I don't know what the liability could be for that. Liability is millions. I'm sure you're thinking because of the loss in income from the NYU doctor. I don't know what Florida's rules for liability for wrongful death are. So Ian is correct in that when we talk about the damages from something like a death, one of the things that the court would look at is what could have been the potential income and contribution that person could have made to the household in the future, and try to evaluate what the price should be paid for that, as well as potential punitive liability if they think that the restaurant did something really wrong, and I don't think this would be applicable if Walt Disney World did something really wrong in this particular instance. So I want to highlight what my wife has to say here. We really do appreciate you all and your patience as we work through some things still on our end to get Hoeg back to videos. Yes, I really, really do appreciate it. And I know that it has been a sporadic kind of video presence here this year. And I'm doing my best to work through a lot of stuff. And I know you believe me on that. So I won't harp on that point. But I do want to second my wife's saying of thank you there. So fantastic. All right. So, folks, I really appreciate it. I really appreciate everybody being here. This has been Hangouts and Headlines. I want to make sure I didn't miss any of these super chats. I did that one. Let's see here. I'm going to go through this list real quick. So I think we're set on this. I appreciate it, every one of you. And I will see you on the next episode of whatever we wind up doing here on the Hoeg Law YouTube channel. Thank you so much, everybody.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.